Things are getting real in the Washington, D.C. federal criminal prosecution of Donald Trump as the federal judge just issued an order regarding the jury questionnaires that will be sent out in the next few months, as a jury will start to be selected in connection with the criminal prosecution of Donald Trump for his attempt to overthrow the results of the 2020 election. And it's right around the corner, folks. I'm Ben Meiselas from the MeidasTouch Network. Let's take a look at the order that was just recently issued by federal Judge Tanya Chutkan regarding the submission of jury questionnaires, when the jury questionnaires will be sent to prospective jurors, and jury selection, folks, right around the corner. Donald Trump doing everything he can to derail this case. Federal Judge Tanya Chutkan keeping this case right on the tracks as Donald Trump does everything he can to try to derail the train of accountability. And just so you know what a jury questionnaire is, it's often employed by federal courts, also sometimes state courts, and especially in cases that could be controversial. These are written questions to try to kind of pre-screen prospective jurors based on written answers so that you don't have to call all of these prospective jurors one day and start asking everybody all of these questions and then have people raise their hands and bring people in groups of 60 or 80 or however many people the courtroom can handle, only to learn that they're biased and they can't be impartial during the case. So this is a way to try to kind of screen and get rid of certain prospective jurors who on the written responses can't be fair and can't be impartial based on the written response. So it narrows down, it streamlines things. That's what a jury questionnaire is. Here, Judge Chutkan writes, having considered the parties' briefs identifying certain jury procedures that both parties have agreed upon and for good cause shown, the court orders as follows. The court will use a written questionnaire in advance of in-person jury selection. The government will prepare a written questionnaire for distribution to prospective jurors and meet and confer with defense counsel regarding the questionnaire before submitting it for court approval on January 9th, 2024. It's right around the corner, folks. To the extent the parties do not agree on any question, the government, at the time it submits the proposed questionnaire, shall also submit a joint filing identifying the disputed language and succinctly stating the parties' respective positions. After review and approval by the court, the questionnaire will be distributed to prospective jurors, summoned to complete it at the courthouse on February 9th, 2024, folks. Also just around the corner. So that procedure is, if the parties think a certain question could be prejudicial or could influence prospective jurors not to be impartial, or can say something that's prejudicial against one side that really doesn't belong in screening out prospective jurors, then the parties can object succinctly, explain the judge their reasons, and the judge will make a decision. This question's good, this question can't be asked. It can be a very tedious process, as you could imagine, and it's not unique, by the way, to this case. I've seen this used in lots of federal cases and even in lots of state court cases, but you see it more in federal court and in cases like this. 2, it's from Judge Chutkan's order. Although the parties may conduct open source research regarding prospective jurors, they may not do so in any way that involves direct contact or communication with a prospective juror, nor may the parties use non-public databases for juror research. The parties must ensure that anyone permitted access to sensitive juror information understands that he cannot publicly disclose the information, and no party may provide jurors identifying information to any other entity, for example, the defendant's campaign, that is not part of the defense team or the government team assisting with jury selection.
Good health starts with good habits. Quip makes it easy by delivering all the oral care essentials you need to take care of your mouth. The Quip electric toothbrush has timed sonic vibrations with 30-second pulses to guide you to a dentist-recommended 2-minute clean. It's lightweight and sleek. The design is for adults and kids with no wires or bulky chargers to weigh you down. The Quip toothbrush also has a multi-use travel cover that doubles as a mirror mount for less clutter and reusable handles in a range of sleek metal hues as well as bright plastic colors, sure to make a pop to your bathroom counter. And so you know, the electric toothbrush isn't all Quip has to offer. The water flosser hits all the right spots with a gentle or deep clean pressure at the touch of a button, and the Quip mints and gum are incredibly refreshing. I truly have Quip to thank for my entire dental care routine, and I don't know where I'd be without them. So listen, it's time to skip the batteries and snap into healthy habits with the new Quip rechargeable electric toothbrush. All the features of the original Quip plus one magnetic charge powers up to 3 months of brushing. If you go to getquip.com/Meidas right now, you'll get 20% off any electric toothbrush, mint and gum dispenser, and water flosser. That's 20% off any electric toothbrush, mint and gum dispenser, and water flosser at getquip.com/Meidas, spelled GETQUIP.com/Meidas. Quip, the good habits company.
And so embedded in this order is almost like a mini gag order, if you will. And it's not unique to this case because, you know, the privacy of prospective jurors and juror information, especially when they're not selected to the jury, is something that is kind of sacrosanct in our judicial process. And so it's not unique language here, but it is language that Special Counsel Jack Smith requested. And also, as technology has evolved, social media searches have become a big deal, a big subject matter in the legal profession, especially when it comes to issues like choosing jurors and jury selection. Can you search through prospective jurors' social media, their Instagram accounts, their Facebook accounts, their Twitter or X accounts, and see the types of things that they post? The answer is, if it is public, yes. It's when they refer to open source research regarding prospective jurors. But what you're not permitted to do is, and this is unlawful, you could be sanctioned for it, you are not allowed to conduct private searches of prospective jurors where if a juror's page is not publicly facing, you can't like ask to follow the prospective juror and then become a follower. You can't like become like a LinkedIn follower or gain extra information, or a Facebook follower. You can only look at what is publicly facing and open source. And what you can't do either here is you can't share the information that you gather about prospective jurors with anybody at the campaign or any other type of third party. You can't conduct other types of background checks or background searches on prospective jurors here as well. It just has to be open source, anything that's available on the public record, and that's it. That's what the court is saying there. And then finally, no party may disclose, either in open court or outside of court, prospective jurors' names or any identifying information. And so, again, that is not unique to this case, but certainly it is something that Special Counsel Jack Smith requested and wanted in this order, and Judge Chutkan provided. And so, look, folks, this is important because the process of jury selection has now basically officially started. I mean, the questionnaire process and the briefing on that is now started. The questionnaires will be sent out in February. The questions will be agreed upon by January. And it also gives you insight into the fact that Judge Tanya Chutkan, as I said earlier in this video, is not slowing this train down. This case, in her mind, is going to trial on March 2024. That's a message that is definitely being sent here. At the same time, Donald Trump is doing everything possible to delay that inevitability, to delay or try to stop that from becoming an inevitability. For example, we covered on another hot take that Donald Trump filed a motion to stay or stop the entire case. while his motion to dismiss for presidential immunity, a completely frivolous motion that he filed, is pending. So Trump says, while I have this presidential immunity motion pending, you must stop the whole case and stay the whole case. And Donald Trump also then filed a opposed motion for extension of time to file all of the other pretrial motions. So extensions of time, stays, judge, delay, right? And whereas Judge Cannon has been agreeing with Trump's lawyers. She does anything Trump's lawyers say. And not only that, but she's like stayed her own dates and deadlines and just delayed everything in her case. It's just a total and utter mess in the Judge Cannon case. Here in the Judge Chutkan case, even though she hasn't officially responded as of this recording to these motions, she basically has responded, right? And her response is, jury selection, we're moving this case to trial March of 2024. February 2024, the questionnaire gets out. January 2024, you submit the questions to me. We're moving this case along. So there you have it, folks. Big update there. Things are getting real. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. And check us out at patreon.com/MeidasTouch. And have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.